Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a very old and landmark judgment on cross-examination of a witness. What further cross-examination is there? And how to contradict a witness? The object of the cross-examination. All of them are explained in the 6 judges bench case called as TAHSILDAR Singh and others versus State of UP 1959. You can see the citation AIR SC page number 2012. Right. So the main focus on this case is on section 145 of the Evidence Act and also regarding the statements given to the police under section 161 and 162 of the CRPC. Actually, the story moves around all these things. So anyway, to give a brief facts, actually this is a gang war on 16/6/1954. Man Singh gang, which is a dreaded Dacoity gang, they have actually stormed the function of Asharam, who is an informer to the other gang, and shot dead Asharam and another. But actually they shot another person by they mistake him as Asharam and left the spot. So ultimately they were actually arrested, the case was charged, and out of the 16 or so, 14 were acquitted. Only this Tahsildar and Shyama Malla, they have been convicted. While the prosecution case is going on, the judge, you may be knowing, according to section 145 of the Indian Evidence Act, and from there the serial number runs, where the judge can ask the questions to be permitted, and he need not permit certain questions also. Now the important points I am going to tell you, point wise they have given. So as per 145 of the Indian Evidence Act, an accused is entitled to cross-examine the witness under the first part of section 145 with respect to police statement. So that means here actually they have asked, did you inform the IO that the accused rolled up the bodies of Asaram and Bharatram and things like that? It was not written in the police statement, that is 161 statement. Second point, a statement to police can be used under section 162 CRPC only, that is for contradicting a witness. So already you are well aware that the statement of a witness recorded by the police and which is not signed by the witness is useful for contradiction and omission only, because it doesn't bear the signature. So whatever you say before the court and when you sign it, it becomes evidence. The police statement, so the statement given to the police can be used only under 162 CRPC. And please remember, omissions, they do not amount to contradictions. Omissions are different, contradictions are different. So in this connection, what is omission, what is contradiction, you have to know. Suppose if you say to the police that we saw the accused persons through the sunlight or through this electric light, right? But in the evidence, if you do not say like that, and that means in the evidence when you go to the court, you say that yes, we saw the accused in the broad daylight or in the moonlight like that. So then it is an omission. So the advocate on the behalf of the cross-examiner, he will ask you, dear friend, you have told the police that you saw the accused person in the electrical light. So this is omission. Then what is contradiction? So please remember, contradiction means saying one thing and not saying that. So likewise here, this can be taken as a contradiction also. What happens is, suppose if the witness in the police statement, it is written that the witness was coming from Layarpeta Sai Baba temple and passing through Mahalakshmi street in that 161 statement. Whereas when he comes before the court and he says that no, I am coming from Damodaram public school. Of course, both routes are there to reach that Mahalakshmi the Mahalakshmi tree. So this is contradiction. So omissions and contradictions. Omissions will not amount to contradictions. Then please remember the irrelevant and material omissions. Please remember they amount to vital contradictions when it can be established by the cross-examination by confronting the witnesses with his previous statement to the police. Yes, the contradiction can become an omission when you confront him, because Arey Baba, you told the police like this, now you are saying like this. What is this? Normally the witness say, no, I did not tell the police like that. Then it becomes a contradiction, right? So basically, what is the purpose of cross-examination? This is more important. And in number of judgments, Honorable Supreme Court of India also said that the purpose of cross-examination is to test the veracity of a witness in chief examination, to test the veracity, please remember, and also to discredit his evidence. Not only it is the right of the accused to shake or discredit the evidence of a witness, but it is also duty of the court. Please remember, duty of the court to presume the witness is speaking truth till it is found unreliable. So, duty of the main purpose of the cross-examination to discredit the veracity of the witness. If you know this much, it is sufficient. Of course, art of cross-examination is obtained only through practice. Normally, it will not be told in colleges in detail. Better you consult your senior lawyer or observe the court proceedings. Then only you will come to know the art of cross-examination, because every case, the facts and circumstances of each and every case, they differ. There is no straight-jacket formula for cross-examination. Of course, some questions are quite common, but if you go delve deep into the case, the questions will definitely vary. Anyway, this is the landmark judgment on the cross-examination of a witness and the purpose of cross-examination and the police statement, veracity of the police statement like contradiction. All these things have been discussed in this particular case. This case generated in the year 1959, and Honorable Justice Koka Subbarao, who is an Andhra, he was also one of the judges in this particular case. So please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.